Thank you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We're coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email him directly with contact information you'll see on the last slide. Which is a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from market analysis support to proposal writing and also post-award compliance. More information is on our website, so please visit us there. Our speaker today is Timothy Furran, and he's going to be covering set-aside advantage and mentor-protege relationships. Thank you, Tim, for joining us, and I'm going to go ahead and hand it over to you.
Thank you, Mallory. Again, I'm excited to be a part of the Jennifer Schaus webinar series and certainly appreciate the invitation. Good afternoon, everybody. My name is Tim Furran. I'm a partner at the law firm of Ward & Berry in Washington, D.C. I focus my practice on federal government contracting and have over 16 years of experience both as a government attorney with the Army and in private practice. Today we're going to be talking about set-aside advantages that are associated with mentor-protege relationships. We're going to also take some time to talk about a few of the disadvantages of those relationships. But before we get started, I think it's important for us to focus or discuss, I guess, some fundamental concepts that are going to help us understand the advantages associated with mentor-protege relationships. First, I think we need to know, what is a small business? The Small Business Administration sets numerical definitions or size standards for every nonprofit small business in the United States. These size standards are based on the business's number of employees and the average annual receipts, and they vary from industry to industry and are going to be defined by your NAICS code. To be eligible to participate in small businesses, and the biggest one that we typically see are your 8A business development, the 8A business development program. A business owner must have a net worth of less than $250,000, personal income of less than $250,000, and then the fair market value of all assets of that owner must be $4 million or less. To maintain eligibility, once you're accepted into the program, you have to have a net worth of less than $750,000, personal income of less than $350,000, and then the fair market value of all assets is $6 million or less to maintain eligibility. So there are several different business programs out there, or small business programs that are out there. The first is the 8A small business program, and again, that deals with socially and economically disadvantaged individuals. The second one is what's called the hub zone, or the historically underutilized business zone. And this really deals with residency requirements where the government is trying to steer work to areas that are economically depressed and trying to revive some of those areas. You'll typically see these around military installations that have closed or some other areas that are experiencing some kind of economic difficulties. The third type of small business program out there is the veteran-owned small business program and the service-disabled veteran-owned small business programs. And these are run by the Veterans Administration and the Small Business Administration, respectively. And then finally, we have women-owned small business programs and economically disadvantaged women-owned small business programs. And these programs are geared towards women, and they deal with areas where women have historically been underrepresented in a particular NAICS code. Aside from what is a small business, I think it's important for us to know really two other things. What is a set-aside contract? To help provide a level playing field for small businesses, the government limits competition for certain contracts to only those small businesses. And that's what's called set-aside contracts, or small business set-asides. They're used by the government to help small businesses compete for and win federal contracts. The current goal of the Small Business Administration is to set aside 23% of all the federal contracts for small businesses. And those goals are aspirational, and they're going to be different in each one of the programs that we just discussed. So finally, what is affiliation and why is that important? Generally, affiliation exists when one business controls or has the power to control another, or when a third party controls or has the power to control both businesses. Control may arise through ownership, management, or other relationships or interactions between the parties. So that's affiliation. Affiliation is important because the Small Business Administration determines whether an entity qualifies as a small business concern by counting its receipts, its employees, and other measures, including those of its affiliates. So if we're affiliated with another company, say we're a small business and there's a large business, the large business's receipts and employees would count against us as we look at our NAICS code. Next slide, please. I also think it's important for everybody to have a basic understanding of the different types of partnerships that can exist. We just completed another Jennifer Schaus webinar where we talked a lot about teaming. And teaming is a special type of prime subcontractor relationship that's implemented through a teaming agreement or a subcontract agreement between two or more parties. And typically you'll see a prime contractor and one or more subcontractors. And this is generally how business within the federal government is done, through a prime subcontract relationship or teaming. Now, a joint venture is a business agreement in which the parties agree to develop for a finite period of time a new entity and new assets by contributing equity. The parties control the enterprise and consequently they share revenues, expenses, and assets. And some key characteristics of a joint venture is, number one, it's a separate legal entity. Number two, it includes members with proportionate interest in equity. It's limited in duration, that's that finite period of time. And then it's created for a special purpose. Generally, it's created for the pursuit of a contract award. And finally, it shares profits and losses amongst its members. And finally, the last one I want to talk about very briefly is the mentor-protege. And these are specific programs that allow companies to form a specific type of relationship for the purpose of the business development of one of the companies who's in the relationship, the protege. Next slide, please. All right, a joint venture can include two or more companies. It could be only small businesses or special classes. And if there's two small businesses or special classes, they're going to maintain their size status. It can be only large businesses, and this would typically occur. I saw a lot of this actually in the dredging industry. And you see two large businesses who will go ahead and form a joint venture because they have different capabilities that complement each other for certain procurements. And then finally, you'll see a mix of both small businesses and large businesses. So with limited exceptions, a joint venture of a small business and a large business cannot qualify as small due to that concept that we just talked about, affiliation. And so what are the exceptions to that rule? Next slide, please. All right, generally, members of a joint venture are presumed to be affiliated. And so in other words, when parties form a joint venture, they are considered per se affiliated for whatever procurement's at issue by virtue of the joint venture relationship itself. Next slide. And again, the exceptions to that rule are where each joint venture partner individually meets the applicable small business size standards. So regardless of the combined size of the joint venture partners, if they're both small, the joint venture is going to be considered small. And again, that typically doesn't happen. Or if the member partners of the joint venture are part of an approved mentor-protege relationship. And this is really what I want to talk about, the approved mentor-protege relationships. So under the 8A, what you'll see is there are two different types of mentor-protege programs. The first is the 8A mentor-protege program, and the second is the all small business mentor-protege program. Next slide, please. Next slide. All right, the 8A mentor-protege program. This is an alliance between an 8A program participant who's known as the protege and a large business who's known as the mentor. What typically happens is the protege has identified needs for business development and seeks out a mentor who has the capacity to address those needs. The mentor-protege relationship must be approved by the Small Business Administration before a joint venture is, number one, created, and number two, before the joint venture submits an offer or a proposal for a particular procurement. And under the 8A mentor-protege program, it's important to note that a mentor can have no more than 3 proteges at one time, And this is because the SBA wants the mentor to be able to devote adequate resources and adequate time to help develop the proteges. Next slide, please. The second exception to our general rule about affiliation deals with the All Small Business Mentor Protege Program. This was established in 2016 to extend the Small Business Administration approved mentor protege relationships to every small business. And it's kind of superseded all the different mentor protege relationships in the different various organizations. So really we have the 8A and we have the All Small. It's designed to enhance the capabilities of the protege firms by requiring approved mentors to provide business development assistance to the firms to improve the protege firm's ability to successfully compete for federal contracts. Next slide. The assistance that the mentor can provide the protege is as follows. They can provide technical and or management assistance, and you see this is a key area for a lot of small firms. Especially with regards to as they start growing with regards to the management assistance. They can provide financial assistance in the form of equity investments and or loans. They can provide subcontracts, either from the mentor to the protege or from the protege to the mentor. So in the first scenario, from the mentor to the protege, you'd see the large mentor would give a subcontract to the protege, and this would really be done to help the protege develop its past performance. The opposite case there is where you would see the protege give a subcontract to the mentor, and this would be typically done so that the protege can use the mentor's past performance experience. The mentors they certainly appreciate this because under this particular type of relationship, they get to get into the game that they normally wouldn't be able to get into by virtue of their size. Assistance can also include trade education. Or finally, it can include assistance in performing prime contracts with the government through the joint venture arrangements that we just talked about a little bit earlier. Next slide. So once a mentor is approved, they have certain requirements to be met. First, they have to be a for-profit company. They have to demonstrate that they can fulfill its mentor-protege obligations. Typically, a mentor will have no more than one protege at a time, but again, under the 8A program, they can have up to 3. And small businesses can be both a protege and a mentor at the same time. Next slide. Once they've met those requirements, they have certain responsibilities. And a mentor that fails to provide the required assistance, it can result in the termination of the mentor-protege agreement. Mentors can be prohibited from acting as mentors for 2 years. The SBA may request the agency to stop work and allow the protege to perform. And finally, this could be grounds for suspension or debarment if the mentor violates the terms of the mentor-protege agreement. Next slide. So what are the requirements to be a protege? First, you must qualify as a small business in the primary NAICS code. A protege can only have up to 2 mentors in its lifetime in any program. A protege firm can generally only have 1 mentor at a time. However, there are cases where the SBA will approve a second mentor for a particular protege if it doesn't compete or otherwise conflict with the assistance set forth in the first mentor-protege relationship, and it pertains to an unrelated NAICS code, or if the protege firm is seeking to acquire a specific expertise that the mentor cannot provide. Next slide, please. The mentor-protege relationship typically lasts 3 years. There's a 3-year extension possible. They're reviewed annually to ensure the protege is receiving the identified assistance in the mentor-protege agreement and that the contracts are being properly performed by the appropriate parties. And that gets into our work share or work splitting requirements. Past performance and experience of joint venture members or subs must be considered by the contracting officer. And this is a little bit different than when you look at teaming and how the government has to evaluate past performance and experience. In a teaming arrangement, if it's a FAR Part 15 negotiated procurement, the contracting officer has to consider significant subcontractors' past performance. But if the procurement's being conducted under FAR Part 8, which is required sources of supplies and services, the agency has the discretion to disregard such references. So when evaluating the past performance, when you're dealing with joint ventures, what the FAR says, or what the rules say, is when evaluating the past performance and experience of an entity, submitting an offer for a contract set aside or reserved for small businesses as a joint venture, a procuring activity must consider work done individually by each partner to the joint venture, as well as any work done by the joint venture previously. So this is one of the keys for small businesses, is if you form the joint venture, again, you get the past performance experience of your mentor partner, which is a huge benefit when you start evaluating the contracts. The protege must identify all of its other mentor-protege relationships, and at the conclusion of the relationship, the protege must report on whether it benefited. The government will also be knowing whether or not how the mentor feels about that as well. Next slide, please. So some of the mentor-protege program requirements. There's a written agreement, and the template can be found at www.sba.gov. They've just updated the template. And the written agreement is going to contain a number of specific provisions that deal with the performance of work, reporting, compliance, inspection of records, those types of things. And again, it's important to note that a violation of the written agreement can be the basis for a suspension or debarment. You must also have a joint venture agreement. And the joint venture agreements are going to contain different things, but typically your joint venture agreement with your approved mentor must state the purpose of the joint venture. It's got to designate the protege as the managing venture, and then it's going to designate one of the protege's employees as the project manager responsible for the contract. It's going to state that the protege owns at least 51% of the joint venture entity. And it's going to provide for certain things. You're also going to have to itemize all your major equipment, facilities, and resources, etc. And again, you can find that at the joint venture draft agreements at the SBA website. The application process for the mentor-protege program is pretty straightforward. It contains a lot of the same information that's in the written agreement. And again, the SBA is going to evaluate the mentor-protege relationship at least annually, and there's also certain other reporting requirements. Next slide, please. All right, so some of the benefits of the mentor-protege programs. A mentor and a protege can form a joint venture as a small business for any government prime contract, provided the protege qualifies as a small business. And that's a huge benefit for the large businesses. There's no determination of affiliation or control between a mentor and a protege based solely on the agreement or any assistance provided pursuant to the agreement. And that's that exception that we talked about to the concept of affiliation. And then finally, the protege firm can agree to sell an equity interest of up to 40% to the mentor firm in order to raise capital. There's another benefit that I always like to talk about is in your teaming agreement with regards to subcontracts. When you start talking about your work share, typically the prime contractor has to do 51%, and the subcontractor can only do 49% of the work. Here, when we're dealing with a mentor protege program, the mentor can do up to 60% of the work, which is a little bit different. So these are the benefits of the mentor protege programs. Let's take a look at some of the joint venture advantages. Next slide. So advantages to doing a joint venture for the protege. First, a small business can pursue broader opportunities than it would otherwise qualify for because of the nature of its relationship with the mentor. Second, the small business gets to use the prime past performance record and can use the past performance record of any of its partners. And then this is particularly advantageous when the solicitation says past performance of subcontractors will not be considered. Next slide, please. Some advantages for the mentor to the joint venture. The large business can pursue set-aside opportunities for which it would be otherwise ineligible. Again, the large business can perform 60% of the work. And then lastly, the large business may have more control over contract performance than it would typically have in a teamed agreement or as a subcontractor to a small prime. Next slide, please. Along with the advantages, there are also some disadvantages. Setting up a joint venture is more complicated, and it takes a lot more paperwork, and it can be more expensive. You have to, depending on what the state law is, you have to register the joint venture and go through the state process to make the joint venture its own separate legal entity. All the liabilities are shared by all joint venture members. So the small shares the same responsibilities and liabilities as the large, and the large shares the same responsibilities and liabilities as the small. Joint venture relationships are harder to exit if they do not work. In your typical prime subcontract relationship, you're going to have some kind of termination clause. And here you're not. You formed a legal entity, and it's almost like getting married. You're in it for the life of the relationship. And then finally, it can be a challenge for the joint venture members to speak with one voice. Again, in your typical prime subcontract relationship, the prime contractor is going to be communicating with the government. Here, you're going to have a large and a small, and the joint venture is the prime. So sometimes folks get very wrapped up about what they perceive as things and who's in control of the relationship. Next slide, please. So the specific mentor protege program requirements for all the different entities that we talked about can be found in the following codes of federal regulations. And each one of those is going to be a little bit different. What I would certainly like to highlight for you is number 5, that if you're a veteran-owned small business or a service-disabled veteran-owned small business, you're going to have to separately register in vet biz. Next slide, please. So again, my name is Tim Fern. I'm from the law firm of Ward & Berry in Washington, D.C. Thank you for joining us today. I hope that you have a better understanding about some of the advantages and disadvantages that are associated with the mentor-protege relationships, and certainly hope you have a better understanding about what a mentor-protege relationship is. I'm happy to answer any questions at any time and can be reached at tim@wardberry.com. Thank you so much for joining us.
Thank you, Tim, for sharing your knowledge and insight today. This will be recorded and posted on our website and YouTube channel within about 48 hours. If you have any questions, please contact Tim directly. And that's all for today. Thank you, everybody.
Thank you, Mallory.